Morning, everybody. Thank you for joining us for this morning's HR Insights on Employment Rights Act Essentials and the increased unfair dismissal rights and beyond. This morning, Carissa, Poppy, and I will be going through the unfair dismissal rights and effectively what you can expect coming up in the future. What I would say is, in respect to questions, we've got a bit of time for questions at the end, but if you do have any questions after speaking, pop them in the chat and we'll deal with them at the end. What we'll do is pass over to Poppy now, who's going to deal with the current law.
Thanks, Gemma, and good morning, everyone. If we could have the first slide, please, we'll be talking about the current law. So before we get into the new law and the practical considerations to have in mind, we thought it might be helpful just to set the scene and refresh ourselves on what the law is currently. There are some changes coming in relation to unfair dismissal, but the current law will be in force until the end of the year. So we thought this might be a helpful refresher. Now, I won't take too much of your time on this section because I appreciate we're here today to talk about the upcoming changes. But if there are any questions about the current law at the end of the session, just let us know. So the current position is that an employee who has been dismissed may make a claim in the employment tribunal if they have sufficient length of service. So in relation to that length of service, employees currently need 2 years continuous service to bring an ordinary unfair dismissal claim in the tribunal. So this essentially means that an employee has to have been engaged for 2 years. And if they have, then you need a fair reason to dismiss and also need to follow a fair process. So there are some exceptions to the rule in relation to continuous service. So day one unfair dismissal rights already exist for automatically unfair dismissals. So for example, where an employee is dismissed for reasons connected to pregnancy or whistleblowing and so on. But the starting point is that employees generally need 2 years service to claim they've been unfairly dismissed. When it comes to compensation for unfair dismissal, we have 2 elements. So we've got a basic award and a compensatory award. These will stay the same going forwards in terms of the elements of compensation. So the basic award is the same as statutory redundancy, essentially. So this is paid to reflect the fact that the employee has been unfairly dismissed, and it's calculated based on the age of the employee, their pay, and their length of service at the date of dismissal. So there is a cap on a week's pay for the purposes of calculation, which is currently £719, and this will increase to £751 on the 6th of April this year to account of inflation. So this cap is unaffected by the Employment Rights Act 2025, and it will continue to apply for the purposes of calculating statutory redundancy, basic awards, and so on, subject, of course, to the year-on-year inflation increases. Then we have the compensatory award. So this compensates the employee for financial losses suffered as a result of any unfair dismissal. So it will include things like basic pay, pension loss, bonuses, commissions, and the total compensatory award is currently capped at the lower of 52 weeks pay or £118,223. Again, this figure is usually increased year on year to account for inflation, and as of the 6th of April, it will be £123,543. So that's the cap that will apply to compensatory awards for claims and dismissals this year. The cap on compensation has particularly limited compensation for high earners and all those with good bonuses or commission schemes, for example, and it's historically limited the financial exposure for employers in high value tribunal claims. So at the moment, what we see, and I'm not sure whether this will change going forward, remains to be seen. Many employees currently introduce some form or try to introduce some form of discrimination to essentially lift that cap. Final point from me is just in relation to time limits currently. So the current time limit for bringing an unfair dismissal claim in the employment tribunal is 3 months less 1 day of the date of the dismissal. There's an early conciliation requirement, so employees have to contact ACAS to notify them of a dispute within this time frame, and then the ACAS early conciliation period can last 12 weeks. So that can end sooner in some circumstances if the parties elect it, but generally it will be 12 weeks, and that pauses or extends the time for bringing a claim. In practice, therefore, employers don't see claims for quite some time following dismissal. And that's all I had to say in relation to the current law. It's the baseline against which the Employment Rights Act reform should be understood, and that's a good place for me to hand over to Carissa. So thank you.
Yes, morning everybody. Thank you for joining us. So, as Poppy said, I'm going to talk you through the new position under the Employment Rights Act, which got ratified in December. So there are really two key changes when it comes to the unfair dismissal regime. Firstly, the reduction of the qualifying period of service for bringing a claim, and secondly, the removal of the statutory cap on compensatory awards. I think the first one really has been the headline grabber of the two, and that is from the 1st of January 2027, the qualifying period to bring an ordinary unfair dismissal claim is going to be reduced from 2 years to 6 months. So anyone who has 6 months continuous service or more on the effective date of termination of their employment is going to be able to bring an ordinary unfair dismissal claim from the 1st of January. I think those eagle-eyed amongst you are going to notice that means that anyone who starts work before the 1st of July this year is going to have that 6 month service crystallising when the provisions come into force at the 1st of January, so they are going to be caught. The other key issue relating to the unfair dismissal regime is the removal of the statutory cap on compensatory awards. You recall that Poppy explained that currently there is a cap on compensatory awards of the lesser of 12 months' pay or £118,223. Now, this is going to be removed, and the compensatory award going forward is therefore going to be uncapped, as is currently the case for claims such as discrimination and or whistleblowing. This change is also coming into force with effect from the 1st of January 2027, so isn't going to apply to dismissals which take place before then. Another broader change, which will also impact unfair dismissal as well as other claims, is going to be the extension of the time limits for bringing a claim. As Poppy said, it's currently 3 months from the date of the act complained of that you have to bring a claim in the employment tribunal, and that's going to be increased to 6 months. So you can foresee that's going to result in an increase in the number of claims being brought. We don't have an exact time period, exact implementation date for that yet, but it's anticipated to be towards the back end of this year. And then finally, in terms of changes, there's going to be an increase to the ACAS conciliation period from 6 to 12 weeks, which I think is probably going to result in further delays to resolution. However, some of you may have already experienced this, and the fact that the ACAS system, like the tribunal system, is totally overwhelmed at the moment. I've certainly had a few claims coming through, or claims that have been notified to ACAS, and actually the ACAS officer isn't being allocated until after the 6-week conciliation window has passed. And so by the time we get told that ACAS has been contacted, the ACAS certificate has already been issued. Now, I suspect this change may be partly driven by that, but I don't really see how it's going to lessen the burden on ACAS officers. If anything, it's just going to result in more delays, I'm afraid to say. So the overall impact of the changes then, well, more claims, I think, for an already overstretched tribunal, and the claims that we are going to see are probably going to become more expensive, more complex, and potentially much more valuable because of the removal of the cap. So before moving on to discuss the practical impact of all of this, we did just think it would be useful to share a timeline for implementation of the provisions. As you'll see there, that the Employment Rights Act received its royal assent in December 2025, but none of the provisions took effect straight away. In relation to unfair dismissal, obviously the key date is going to be 1st of January 2027, when the 6-month qualifying period takes effect and the removal of the compensation cap. But before then, later on this year, we're expected there to be this extension to time limits for bringing a claim, which is obviously going to also have an effect. And then going forward, I think throughout 2027, we're going to see a number of reforms under the Employment Rights Act taking effect, which could also have an impact on unfair dismissal claims, and that includes things like collective redundancy thresholds, day one rights for bereavement leave, etc. So yes, lots of change coming. I think we can safely say 2026 is a year to get prepared, because 2027 is going to be jam-packed with implementation of various provisions which are going to have a significant impact for employers and indeed on employees. And let's not forget the poor and already suffering tribunal system. So I'm going to hand over to Gemma now, who's going to talk you through some of the practical considerations we need to be thinking about as we find our way into this busy time.
Thanks, Carissa. As Carissa mentioned, I'm going to be discussing the practical considerations that arise as a result of these changes. And I think what's really important is effectively the advice we're giving at the moment is for employers to really drill down on their recruitment processes. I think there was a time where employers may have been a bit more relaxed and potentially taken a gamble on somebody at recruitment process. They weren't 100% convinced if they were the right fit or they were suitable for the role. Maybe they needed a bit of training, skills weren't quite where they needed to be. Most of the employers that we're dealing with at the moment, and definitely the advice we're giving, is actually making sure that your recruitment processes are significantly more rigorous. And effectively, if you have a doubt, query how big that doubt has to be. But if there are those concerns, are you going to take the risk now, given that there is this additional protection, and that could therefore create more liabilities for you going forward? I think it's likely that will also relate to stronger pre-employment checks. So maybe more references, stronger references. Of course, part of the issue with that, as you'll all appreciate, is that most employers now give a standard factual reference only. And in fact, our advice tends to be that if an employee has a better than standard factual reference, so that's dates of employment and job title only, that tends to suggest that there's some kind of settlement agreement or exit that has gone on from an employment perspective. So if the employer gives a glowing reference, that's almost a beacon to the fact there's something more to it. But of course, if it's a personal reference from a manager, that's slightly different. Separately to that, I think we're going to have to see, and employers will need to implement better probation management. At the moment, it's fairly common, unfortunately, for us to get a call to say they've got this employee, they've got 18-month service, for example, they passed their probationary period, let's say 6 months ago or even a year ago, and they were fine because employees, hopefully, you'd hope, would be excellent during their probationary period and going to do everything by the book. And actually, as time has passed, it's abundantly clear that they're not really up to the standard we need. And of course, at the moment, subject to any whistleblowing and or discrimination arguments, they can't, there's limited scope for them to bring a claim in the employment tribunal on the basis they just don't have the relevant service. Effectively, with this change to the qualifying service being reduced to 6 months from start date to bring unfair dismissal, is going to be very challenging for you to effectively have, well, you won't be able to run that argument because employees will then be able to bring a claim, which really limits your ability, in my view, to look to manage staff outside of the probationary period. Now, it doesn't mean that if you have, for example, a 3-month probationary period, you can't dismiss in the 3 to 6 month period, having successfully completed probationary period, but it's just something to be alert to. I also think it's really important. A lot of clients we're speaking to are saying they'll have 6 month probation periods. I think that is a nice thing to have. I think that psychologically people like to have 6 months, 3 months, or a year. There's symmetry to that. Fundamentally, I think my view would be actually put down a 5-month probationary period. The reason being that if there is any drift in the probationary review period, you aren't going to inadvertently end up in a situation where an employee acquires a service they need to claim unfair dismissal, even though you're dismissing on a probationary, failure to meet probationary standard. And that's really important. Related to that, you're going to have to be, I think, fairly stringent from a HR point of view in respect of diarising probation reviews, making sure that any concerns are documented. Now, they don't need to necessarily be put to employees, but they should be clearly documented so you can rely on them. And I suppose it's a case of actually, and we've got one client who's actually doing a 5-month probation review with a 3-month mid-probation review. And again, going back to the point I made around if there's a niggle, they've made it very clear to me that if they are concerned at month 3, they won't be taking the risk and will be looking to dismiss at that point. Of course, you have to balance that against the inherent costs and time that will be spent recruiting staff, because if you're dismissing everybody on the probation periods, there's going to be a cost there. As Carissa mentioned, you need to be alert to the fact that this will apply to staff from effectively July of this year. So don't be thinking you can employ somebody in September with, say, a year's probation period, and then look to dismiss them for failing the probation period in, let's say, June, with a view to them not being able to claim unfair dismissal. They absolutely will be able to do so. An alternative, if you want to, and I know some of the clients we work with are of the view that actually 5-6 months just isn't long enough for them to properly consider if somebody is suitable for the role in their probation period. So what they are doing is they are keeping a longer contractual probation period, which I'm not massively comfortable with, but I understand the rationale for that. And they are instead implementing a formal probationary review process and policy, which is something most employers we deal with don't tend to do. The benefit of that, of course, is it does limit the risk of an unfair dismissal claim. However, you do still have to fit within those 4 reasons of fair dismissal, which sometimes on a probation period review or dismissal you just wouldn't do so. In respect of the removal of the cap, there's been a bit of commentary about the fact that that will result in fewer whistleblowing and or discrimination cases, on the basis that currently we get quite a lot of those, because it means that, 1, people don't have to have the 2-year service, and 2, they can have uncapped losses at the moment. In theory, I understand that. I'm not sure actually that's going to be the case, because there are elements, for example, on a discrimination claim where individuals can claim more. They can claim injury to feelings that isn't available for an unfair dismissal claim. And I think there is still a social view that discrimination claims and whistleblowing claims are more problematic for employers. So people will still look to bring those if they can. And definitely the cases that we're seeing at the moment, it's very rare for us to get just an unfair dismissal claim. And I don't fundamentally see that changing, albeit from a senior exec perspective, where there are unfair dismissal claims only, they're going to effectively be far more expensive. I think it's really important to just bear in mind that these changes come alongside a huge increase in cases and disputes in the ET generally. Carissa mentioned the delays we're seeing. Those are prior to any changes, and I think are in part due to the change in government. So the talk around increased employee rights, the advent of AI. I mean, I think if I see 1 grievance letter written by ChatGPT a day, I'm seeing 10. So I think that information is readily available, and people are prepared to pursue their rights. Now, it used to be the case that if an employee wasn't happy, they'd resign. At the moment, we're almost getting, a lot of my clients will get a request to say, I'd like to resign, but what does my exit strategy look like? And that's really important. So I don't necessarily see that changing. And just to give you an idea, and this is something to bear in mind, because from a liability perspective, where there is such a backlog in claims, and I think that will only increase as a result of these changes, you're seeing cases being listed for several years in advance. So we had a case yesterday that's being listed for 2029. What that means, of course, is that you need to make sure your witnesses are available, and effectively it changes the way you're running litigation, because rather than wait until closer to the hearing to get the witness statements done, you're doing it closer to the claim being raised, so sometimes 1-2 years in advance, to make sure that people can properly remember what's gone on, and therefore that'll make their evidence a bit more compelling. So I think, from takeaway perspective, given all these changes, I think you need to be looking at your dismissal policies, if you have any, your template letters, making sure your managers are very clear on probation periods and how they work, and that HR are overseeing that, and making clear that your probation periods, the 6-month period, or let's say the 5-month with a little bit extra, is critical, because liabilities that arise after that. And now we've got a bit of time for questions. And I can see there are 2. So I've got one question. Do you recommend temp to perm as an alternative? I'm happy to that. Carissa, Poppy, do either of you have a view?
I can see it can help manage expectations in employees around the processes that you're going to be going through come the end of their temporary contract. So I can see that could be attractive to some employers as a way of making sure they're going through the correct processes in terms of renewing contracts at the end of the temporary period. However, I mean, practically speaking, if you've got any kind of concerns about performance, you should be addressing those anyway. But I do appreciate that's in an ideal world, and so this may be a way as a mechanism of prompting reviews at regular interviews, and indeed, focusing everyone's minds on it as the end of the temporary period comes to effect. So it may be helpful for some employers. I wouldn't necessarily jump to tell clients you should always bring people in on a fixed term contract to start with and then make them permanent, thereafter, because that can bring its own issues as well.
And I think what's really important is temp to perm, even if you're going through an agency temp, there are arguments around umbrella agreements and service. So effectively, I think it would be problematic for you to think, well, we've had someone on a temp contract for 3 months, we're now starting them on a per contract, and we can ignore the first 3 months. The reality is, all of that's going to count towards their service. So you arguably have a shorter period. And I think there's a psychology around, if I've been a temp and I've been given a permanent contract, I've almost passed my probationary period. So what then happens for me to then be dismissed 1, 2, 3 months later? So I think that could be psychologically a situation where you have staff who feel more wronged by being dismissed rather than I'm on a permanent contract and I failed my probationary review. But it's something you can definitely bear in mind.
I think it's also the case if you're wanting to avoid having the temporary period of service contributing to their continuous service, I could foresee getting into difficulties around that if there's not been any break in the provision of service. You're probably going to be stuck with the 6 months anyway. So I can see some appeal, but overall, I don't think it's something I would necessarily be recommending.
I think if you're not doing it anyway, my view is I wouldn't be necessarily changing to accommodate it just because of this.
Yeah, sorry, that actually ties in with Dawn's question as well. We work with a lot of casual workers. They work on a casual agreement. Should we consider they will fall into the 6 month period? It's the same issue, really. If they are working for you and that then becomes a permanent contract, you definitely need to give consideration to any time they've spent working as you as a casual employee as to whether or not that would count towards continuous service, because in most cases it probably would, I would say.
And there's a comment here on the chat that we know you'll be able to see that actually the part of the issue with temp to perm is that you could be reducing our candidate pool because, of course, individuals may not be massively attracted to a potential permanent role, not a guaranteed permanent role. So we've just done a couple of questions there, which is quite handy.
I like sorry, you go, Gemma.
You go, Carissa.
I was going to say, I like the question about the employee who isn't performing. They've been with you 3 months. They then go on long-term sick for the second half of their probation. Canny employee.
It's standard practice nowadays.
But you hear about it so much. Absolutely. Well, my personal view is you have to be fairly robust with that kind of practice, and you obviously have to be mindful of what is the reason they are on long-term sick, and perhaps do some further investigation into that. And it might be you very quickly need to trigger your sickness absence management policy to find out what the reason is for their absence and see if it's justified, and indeed see if it gives you cause for concern around disability discrimination. But yeah, you do need to face it head on, I think, and make sure you are proactive in managing that absence as soon as this happens. If it's a pattern you are seeing, then yes, be proactive, because actually if push comes to shove, you may well decide you're going to terminate anyway before they get their 6 month service and run the risk around the illness and any possible claims around that. But obviously it would be fact dependent.
I think it depends quite a lot on two things. One, the level of sick pay you have, because I think if sick pay is SSP only, depending on the rate of pay of the employee, it's unlikely they'll be signed off sick for 3 months. I mean, they might be, but most employees couldn't wear that loss of income. Secondly, and I think what's quite important is that for me, it's going to all depend on the reason or how close you were to dismissing before them going on sick leave. Because if you are saying that actually you had concerns, you were due to dismiss, but they just got in there first, those concerns don't change, and you can dismiss based on those concerns because they predate any potential sickness absence, subject to whether or not the concerns relate to a potential disability. But it seems to me that actually If you're just thinking they weren't quite right, but we wouldn't necessarily have dismissed, and they look to extend by sick leave, that's going to be a bit more problematic. We've then got a question on fixed term contracts for gap students that are a year long. Poppy, I don't know if you want to deal with this one.
Yeah, I can take that. There's a couple of questions on fixed term contracts actually. In relation to fixed term contracts, if they're going over the 6-month period, provided the individual's an employee, that continuous service and the protections likely to click into place. And the other thing to say is that the expiry of a fixed term contract is technically a dismissal as well. So for those individuals that aren't needed beyond the fixed term, you might be needing to look at a redundancy process as well, just to make sure that it's a fair dismissal. So absolutely something that you need to be bearing in mind in terms of those arrangements going forward. I don't think that's going to be a way of avoiding the protection coming into force, unfortunately.
And I think what's really important, just picking on the point there about the redundancy, is of course, and I've had this come up with a couple of clients where they've got employees on a fixed term contract who've stayed 2 to 3 years. They've already got their 2 years service now. And it's in a question of actually, to follow a fair process, as you'll all appreciate, should you be putting all of your staff who've got more than, you're not on fixed term contracts at risk of redundancy too? How does that affect your workforce? So that's something else to bear in mind on the fixed term contract piece. We've got a comment around 6 months is a typically vulnerable period after a major life event, for example, a job change. So 9 months is better to avoid losing potential talent. And I absolutely understand and accept that. I think it's going to be a case of potentially, for doing a 9-month probationary period, look at a review at 5 months to see what concerns you have. I suppose the point there is that actually at 5 months, people may not be performing because of everything they've had in respect to the job change. There's going to have to be a view in the business in respect to the level of risk they're prepared to take. Next question is employees for tax purposes, would they also be covered by the 6 months? Carissa, Poppy, would either of you like to say that one?
I'm happy to. So I'm assuming in relation to this question, we're referring to the IR35 provisions and the fact that in that kind of scenario, you've only got 2 employment statuses. You've got employee and you've got self-employed. That's distinct from the employment rights provisions in relation to employment status. So possibly, but not always, is the answer to that. I know that's a vague one, but it will depend entirely on the circumstances and the mutuality of the obligations, the level of control that you have over the individuals and so on. So ultimately, possibly, but not always.
In fact, there's a couple of questions on casual workers, and that will be exactly the same. If they're genuine casual workers, chances are they won't be caught. But if they are casual workers in the sense that there is some kind of obligation, mutuality, and or control, the chances are they will actually flip into an employment status, and the service provisions would apply. And there is one final question, which means we should finish bang on time, is whether or not we'd recommend changing disciplinary and capability procedures so that during probation, staff are given a formal warnings. Effectively, that means that they get one last chance to meet performance standards. You might really have them on a final warning. My view, and I'm happy, Chris, and probably for you to share your views, is that actually I wouldn't do that. So my concern with doing that is that twofold. One, it means that if you know somebody is definitely not appropriate for the role, let's say month 2, you've got to go through a really clunky process to dismiss them, and no one's going to thank you for that. More importantly, or equally as worryingly, is that if you go through that process, fundamentally, if you've got somebody who gets to a final warning on, let's say, month 5, my concern there is you're giving them a heads up that dismissal's on its way, which means that they could get themselves signed off sick. But, inevitably you're going to get a grievance. The playbook that we tend to see tracking out where staff think they're being dismissed is, I've got this grievance against my manager, or I've got a disability, and that will all land. Whereas if you've got the concerns but you haven't necessarily gone through a formal process, it seems to me that you've got a bit more flexibility on dismissal. Carissa, Poppy, I'm not sure if either of you have anything to add on that one.
No, that would have been my response as well.
Perfect. Well, thank you, everybody. We have we're just a minute over, sorry, but hopefully you found it useful and that minute was worth it. We'll be the next session. We'll be in touch with you about that, and I hope you'll have a lovely day.
Thank you.
Thanks all.